Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith-Rogers, producer of Public Health on Call. Today, Joanne Rosen, an attorney and practice professor at the Johns Hopkins Bloomberg School of Public Health, speaks to Dr. Josh Sharfstein about two consequential legal cases about abortion coming to the Supreme Court this term. Let's listen.
Joanne Rosen, thank you for joining me again on Public Health on Call to talk about litigation related to abortion. We've spoken a few times. We certainly spoke right after the Dobbs decision. And one of the parts of our discussion and of that case that I remember is that the logic by the justices who voted to strike down Roe versus Wade was that it would get the courts to some extent out of the abortion issue. It was now headed back to states. Did I remember that right?
You do. That's correct. What the Dobbs court said very clearly is that they were returning the question of abortion regulation to the people through their elected representatives, and states and Congress would then be able to regulate abortion in a way that reflected the wishes of its residents or citizens. And I think implicit within that, explicit returning it to the states, was the expectation that the Supreme Court would be able to be removed from adjudicating all these abortion disputes. So that, I think, really was the hope of the majority in Dobbs.
That's what they were thinking then. How does it look now?
Abortion was extraordinarily fraught and litigious and controversial for all of the years between Roe and Dobbs, and it has, to a large extent, continued that way since Dobbs. So far from calming the waters around abortion, Dobbs, in fact, has set off a new and quite intense round of litigation, most of it taking place in state courts, but some of it coming up to the Supreme Court.
Well, let's talk about, maybe very briefly, the kinds of cases that are coming up in states, and then I want to focus on the Supreme Court. We certainly have seen the headlines of women trying to get abortions under some extraordinarily difficult circumstances and not being able to. Is that some of the litigation you're talking about?
Yes, that's exactly what I'm referring to. There have been a number of cases in the 18 or 20 months since Dobbs. The states really have done exactly what the Supreme Court expected. They have legislated, and we have a real patchwork of abortion laws across the state. The 14 states that have banned abortion, with very limited exceptions, have been the focus of a lot of state-level litigation. What do those limited exceptions permit? Under what circumstances can someone who's in a medical crisis lawfully get an abortion? And there are a lot of cases out of those states are taking up a lot of space in state-level courts. It's not all of it, but that really is a lot of what the litigation looks like post-Dobbs.
And then there's the Supreme Court, because here we are a couple of years later, and there's some major cases coming at the federal level too.
Yes, there are two in particular that the Supreme Court has agreed to hear this term that will be heard sometime between now and the end of the court's term, with two rulings expected come June. There is one case involving the ongoing litigation around the FDA's approval of mifepristone, and a second case involving guidance that the Department of Health and Human Services put out about obligations under a federal statute called EMTALA for providing care to pregnant patients. So those two cases between December and January have landed on the Supreme Court docket.
Well, let's talk about each of those in turn. So the mifepristone case, this is a case where a judge actually struck down a big part of the approval of this medication, maybe the whole approval, if I recall correctly.
Yes, that's correct. So the mifepristone case, which is known as Alliance for Hippocratic Medicine versus FDA, it began in November of 2022, not directly related to the changes in the law in Dobbs, but I think very much related to the change in the social and political climate after Dobbs. A group of anti-abortion medical associations and physicians brought a challenge to the FDA's approval of mifepristone. As you know, mifepristone is one of the two drugs that's used in the medication abortion protocol. It was originally approved by the FDA as safe and effective when used in conjunction with a second drug for terminating pregnancies. And then there were subsequent expansions of the conditions under which mifepristone could be used by the FDA. And this coalition challenged all of the FDA's approvals and decisions around mifepristone on the basis, they said, that mifepristone was not safe and was not effective, very much flying in the face of tens of thousands of studies and clinical findings about its safety and effectiveness. And you're right, there was one judge, the first judge in Texas, sided with the challengers and issued a preliminary injunction that reversed all of the FDA approvals and would have taken mifepristone off the market nationwide. Subsequently, the Supreme Court, on an emergency basis, was asked to stay that preliminary injunction, and the court did and said that for the duration of the litigation, mifepristone would continue on the market consistent with FDA's decisions. There was an appeal decision by the Fifth Circuit where the Fifth Circuit allowed some parts of the FDA approval to remain in place, but reversed others. And then in December, the Supreme Court agreed with the Department of Justice's request to review that Fifth Circuit appellate decision. So the mifepristone litigation and the FDA's approval, not the 2000 original approval, but the subsequent decisions that expanded mifepristone availability, those will be heard by the Supreme Court sometime this spring.
It's a lot of legal maneuvering, but there's a lot at stake with this case.
There's a tremendous amount. The sort of two really big issues, and the ones that the court agreed to hear, one has to do with the FDA's capacity to make decisions based on its extensive expertise with respect to drug safety and effectiveness. And in this case, the FDA's review of tremendous amount of clinical data and whether a judge or judges should be able to second guess and overrule the FDA. This case has relevance directly for mifepristone, but potentially for any drugs that the FDA regulates. And if the judges below in the lower courts that reversed some or all of the FDA's decisions, I believe this is the first time in FDA history that a court has reversed an FDA approval of a drug on the basis of its safety over the objections of the FDA itself. So that's one huge piece of the significance. And the other has to do with whether the coalition of anti-abortion organizations that launched this litigation actually have legal standing to bring this claim. Not every aggrieved party can go to court. You have to fulfill the requirements for standing that are set under the Constitution and that the Supreme Court has made clear in decisions. So there's a really large issue about whether these organizations have suffered the kind of concrete and particularized injury in fact that the Supreme Court says is necessary in order to challenge some government action or a statute.
So this case is incredibly consequential because, if I'm not mistaken, mifepristone is used by more than half of the people who terminate pregnancies in the United States each year. It's incredibly important for their healthcare as well as for these bigger issues of FDA and whether FDA can make decisions, as well as who's allowed standing to challenge actions in court.
Yes, that's absolutely true. The most recent data that I've seen indicates that about 54% of people across the country who terminate pregnancy do so through medication abortion, and that's widely understood to be an underestimate. So any change in the conditions under which mifepristone is legally available will affect a colossal number of people's ability to access abortion across the country.
And that includes everywhere, even in states that haven't taken any action to narrow abortion access.
Yes, absolutely. That's one of the most consequential things about this case for states that continue to permit abortion, as well as for states that have banned it. People will find their access is restricted.
So much for the idea that the Supreme Court would be out of the business of regulating abortion.
Yes, exactly. We're back exactly where we started.
So let's go to the second case that you said had to do with the emergency treatment of patients.
Right. That case has to do with EMTALA, the Emergency Medical Treatment and Labor Act. And that is a federal statute enacted by Congress almost 40 years ago in 1986. And the purpose of EMTALA was to address a practice that's been described as patient dumping, the practice of some hospitals turning away people who show up sick in their emergency rooms because they're uninsured or they can't pay. So what EMTALA said when it was introduced in 1986 is that if a person, and it applies to all hospitals that receive federal Medicare funding and have emergency departments, so to almost all hospitals, if a patient shows up in an emergency room, the hospital must screen them and determine if they are suffering from an emergency medical condition. And if they are, regardless of their ability to pay, the hospital must provide necessary stabilizing treatment for that patient. In July of 2022, just a few weeks after the Supreme Court released the Dobbs opinion, the Department of Health and Human Services, HHS, issued guidance under EMTALA for the care of pregnant patients and issued this to all hospitals. And what that HHS guidance said was that if a pregnant patient presents at an emergency room and after screening, they are found to have an emergency medical condition, and it is the physician's judgment that stabilizing treatment for that patient's condition requires an abortion, then the physician would be required under EMTALA to perform that abortion, even if there is a state law that would otherwise prohibit abortion in those circumstances.
So this is a case of federal versus state law.
That's exactly what it is, because the EMTALA guidance says that these obligations would prevail over, or to use the legal term, they preempt any state law, for example, an abortion ban with a really narrow exception. So the EMTALA guidance preempts any state law that would otherwise not permit abortion in those circumstances.
Could you give an example of a situation where this dispute between federal and state law might play out?
Sure. You could have a pregnant patient who has preterm premature rupture of membranes, but the fetus still has a heartbeat. The pregnant person is sick, and she may be determined under the definition of an emergency medical condition in EMTALA. Her health is jeopardized. But Texas, for example, only permits abortion where it's necessary to prevent the death of that person. She may not be sick enough yet, but under EMTALA, the abortion would be required to stabilize her condition. Texas law would say, no, not yet. You have to wait. The EMTALA guidance would say, this is an emergency medical condition. She must be stabilized.
So this case, this dispute between federal and state law will go to the Supreme Court?
Yes. So there were two different lawsuits that were filed shortly after the HHS provided this guidance. Texas filed a case against the Department of Justice saying, hey, no, our abortion law prevails, not your guidance. And a federal court in Texas agreed and said, no, the Texas abortion bans and its exceptions take priority to the extent that they conflict with the EMTALA guidance. And the EMTALA guidance was then rewritten to exclude Texas from that guidance. And that's the law in Texas right now. But almost around the same time, the Department of Justice filed its own lawsuit against Idaho. Idaho, like Texas, has a really narrow exception to its abortion ban. And the Department of Justice said EMTALA's guidance preempts the very narrow medical exception in Idaho. And a federal court in Idaho agreed with the Department of Justice. The Idaho case was then appealed by the state of Idaho all the way to the Supreme Court and asked the Supreme Court to review the lower decision. They want the Idaho abortion ban to prevail over the EMTALA guidance, and also asked the Supreme Court to remove the preliminary injunction that the Idaho court put into place that said EMTALA must prevail where there's a conflict. And the Supreme Court did both. They agreed to hear the appeal, so they will determine whether EMTALA's guidance can preempt state abortion laws where they conflict. And they also removed the injunction of the lower court so that now, where there's a conflict between the Idaho abortion ban and its limited exception and the EMTALA guidance, Idaho's law prevails.
Now, I'm generally used to the idea that federal law trumps state law. Isn't that the usual?
It is the usual, and the reason it's the usual is the supremacy clause in the federal Constitution says that where there is a conflict between, in this instance, a federal law and a state law, the federal law prevails. So there is an issue about whether, in fact, the EMTALA guidance is properly supported by the text of EMTALA itself, or whether HHS exceeded the jurisdiction of EMTALA with the guidance that it provided. And there are some other administrative law issues that are alleged to be at issue here.
So this gives the Supreme Court a chance to do what at least it was saying it didn't want to do, which is wade back into abortion decisions with decisions that are very consequential for health. We're talking about emergency care in many states in the country.
That's exactly what it does for the court. There have been a handful of really tragic cases that have been reported that involve a pregnant person who's suffering some fairly profound complications related to the pregnancy, for which abortion is the appropriate care. And the people have either had to travel to other states because their state bans don't allow care yet in their case, or they're required to wait until they get much sicker, and therefore abortion is required in order to save that person's life, because that's the wording of the state abortion exceptions.
No matter the long-term consequences, right? It's only if it's required to save your life. That doesn't necessarily mean, you'll be able to have children again. Any of those other things don't come into it.
Exactly. You may lose future fertility because a hysterectomy may be required as a result of how ill the person becomes during pregnancy. Both of these cases are very consequential. One interesting piece is that under our system of federalism, the bulk of the authority to regulate abortion is at the level of the states. And while the federal government has some scope to regulate, it is more limited. But both of these two decisions that the Supreme Court's going to hear this term involve federal activities.
Well, Joanne Rosen, thank you so much for explaining these cases. We will obviously be watching very closely, and I'm guessing no matter how they turn out, we're going to ask you to come back and help us sort through them.
Thank you, Josh. I'd be happy to.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, Stephanie Desmond, and Grace Ceciri. Audio production by J.B. Arbogast, Holly Cardinale, Spencer Greer, Matthew Martin, and Philip Porter, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Ceciri and Eliza Rosen. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.